Trespass to land is a tort committed against possession of the land, not against the owner of the land. If someone owns a house and leases it to another person, then if anyone trespasses uninvited, they're trespassing against the tenant, not against the owner. So what actually counts as possession? Dykes was a lodger in a boarding house owned and run by a Mrs. Phillips. So he occupied a room in the boarding house, but the external door which shut out the world was possessed by Mrs. Phillips, who had the only key to the outside door. Monks was not a resident of the boarding house, but had entered the house and was making a disturbance. We don't know any more of the story, but the ruckus obviously got on Dykes' nerves because he came out of his room and physically ejected Monks from the building. Monks sued for assault and battery, and Dykes raised the defence that he was merely ejecting Monks, who was a trespasser. The argument immediately settled on a legal point. Ejectment, the physical removal of a trespasser, was a remedy associated with possession. Only a person in possession of land could exercise ejectment. Could it be said that Dykes was in possession? After all, he was lawfully lodging in a room there which was his, but at the same time he had no means of locking out the outside world. The court found that a lodger does not have possession of the rooms they occupy. Rather, the manager of the boarding house has occupation of those rooms, and the lodgers are there by licence, with permission. Baron Park said, "I think that neither in law nor in common sense can a man be described as being in possession of a dwelling house where he is a mere lodger." The sticking point seemed to be the external door, the portal between the public and the private. Dykes' room had a door, but it was only the portal between one part of the private premises and another part of the private premises. If each room had had a separate entrance, publicly accessible but lockable, kind of like a motel, then the occupants would have been in possession. From this case, we learn that there is a difference between a tenant and a licensee. A licensee is not in possession of land and cannot eject a trespasser.